Certain non-citizen spouses married to U.S. citizens can now gain temporary legal status and have an opportunity to apply for a green card without leaving the country. By the end of this video, you will learn about the new Keeping Families Together Parole in Place program, including a complete tutorial on how to apply, and be sure to watch to the end because we will be discussing the risks and future of this program. You might not want to delay applying. Let's get to the first thing you need to know, which is what is Parole in Place, or PIP. Parole in Place is actually not exactly a new program. It has been used for military family members since 2013. However, the Biden administration recently expanded this program with the goal to provide a way for non-citizen spouses and certain stepchildren of U.S. citizens to overcome their undocumented entry into the United States. In this video, we will cover spouses of U.S. citizens only. Specifically, this program allows eligible immigrants to generally receive 3 years of protection from removal and the ability to apply for a work permit, also known as an EAD, if approved. And there is a massive new benefit to spouses of U.S. citizens with this program. It creates a pathway to citizenship via the marriage adjustment of status process. Non-citizen spouses of U.S. citizens who entered the country without inspection before this program were ineligible to adjust status because that process requires the immigrant spouse to have a valid and legal entry to the United States. Now, if you're granted parole under this program and otherwise qualify for marriage-based adjustment of status, which we completely break down the eligibility requirements for you here, you can then apply for adjustment of status without, and this is big, without being required to leave the United States. That's amazing news since over 500,000 non-citizen spouses of U.S. citizens will be eligible to receive this benefit. So let's get into who and who is not eligible. For spouses to be eligible, you need to be present in the United States without admission or parole, have been continuously present in the United States for at least 10 years since June 17, 2014, have a legally valid marriage to a U.S. citizen as of June 17 of 2024, have no disqualifying criminal history or otherwise constitute a threat to national security or public safety, and merit favorable exercise of discretion. You will need to provide records of your 10 years of continuous residence, that you merit favorable exercise of discretion, and that you meet all other requirements. But don't worry, stick around to the full application tutorial where we will break down exactly how to prove these requirements. So who does not qualify? Those who were last admitted or paroled, which is great news because you won't need PIP to adjust status. You can just go ahead and file for an adjustment of status, have not been in the U.S. for 10 years as of June 17, 2024, were not married to their citizen spouse as of June 17, 2024, are married to a legal permanent resident, are parents of U.S. citizens with no citizen spouse of their own, and have disqualifying criminal history or are inadmissible. For those of you who do qualify, here's how the application process will look like. First, you will need to fill out Form I-131F, and I'm about to show you how to do that. And it's really important to know that this can only be done online. We've also learned that for the first time, you will not receive any notices by mail. This means you will need to set up a USCIS online account and print out all notices in order to complete your biometrics appointment. Second, the USCIS filing fee is $580 with no fee waiver applicable. We've also learned that the USCIS will not be issuing refunds of fees paid for this program, even if the program is stopped by a lawsuit, change in president, etc. We will be discussing all of the risks of this program, including this one, at the end of the video, but let us know with a comment if you think the USCIS should offer refunds to immigrants in case the program is suspended for any reason. Third, you do not need a pending or approved I-130 prior to applying for this program. Fourth, it is okay to have started consular processing, for example, by paying fee bills to NVC, filing an I-601A waiver, etc. And you may now want to switch gears and adjust status instead after gaining parole through this program. The online form even asks you for your waiver receipt number since they want to prioritize those applications, but we will talk about that. And fifth, you will need to provide supporting documentation covering 5 main things: proof of your identity, proof of marriage to a U.S. citizen by the required date, proof of your spouse's U.S. citizenship, proof of physical presence in the United States from June 17, 2014 to June 17, 2024, and possibly up to time of filing, and fifth, that you merit a favorable decision. We are going to cover each of these in detail, including the types of documents the USCIS wants to see as proof in the application tutorial right now. But real quick, before we go there, an approval through this program will make you eligible to apply for a marriage adjustment of status. We've developed a complete step-by-step approach to getting a green card through the adjustment of status process all the way through naturalization with amazing success. We have plenty of interviews with our successful members, so you can learn exactly how our approach works here. All right, now let's jump into the form itself. The form is actually relatively straightforward. What makes it complicated is just all the evidence that you need to come up with, but we're going to talk about it in detail, you're not going to know exactly how to do that. You would generally create a new account unless you already have a USCIS online account, because if you already have it, then you already have some pending processes there, and it's always nice to just use your current account and file this form from there. But if you need to create one, then go ahead and do that, and then from there you would click on My Account, and you would say I'll file a form online. From there you would select Form I-131F, and it's going to show you some disclaimers. It will talk a little bit about the program, and then it's going to take you straight to this point. So you must complete all fields with an asterisk to submit this form. I'm requesting parole in place under INA Section 212D 5A as the spouse of a U.S. citizen. Super easy. Is someone assisting you with completing this application? Obviously, if you need an interpreter or a preparer, then you would say yes, and you would provide that information there. But otherwise, if it's a no, then you just move on. What is your current legal name? Your current legal name is the name on your birth certificate unless it changed after birth by a legal action such as a marriage or court order. Do not provide any nicknames here. So this is my full name. You might also be having a middle name, which I don't. And then from there, it's asking you, have you used any other names since birth? I said no, but if it's a yes, then you would need to provide all the names that you've used since birth. All right, how can we contact you? Your phone number again, and then your email address. And then what is your current US mailing address or safe address if applicable? And you're just going to provide it here. Super easy. Is your current mailing address the same as your current US physical address? Sometimes it's not the case because you might not be able to receive mail at your address. In that case, you would say no, and you would provide your physical address below. All right, your current date of birth, what is your country of birth, and what is your country of citizenship or nationality? Super easy. What is your gender? What is your ethnicity? What is your race? And then height, weight, color of eyes, and color of hair. Super straightforward. What is your A number? So the A number refers to your immigration file number provided by US immigration officials. You might have an A number, but you might not have it. So it really depends. Usually they list an A number on all I-797 notice of action. So that's when you would be able to find it. You can also look it up on your previous files. So let's say you received some immigration paperwork from the USCIS. You might be able to locate it there, but otherwise, if you do not have it or you do not know it, then you would just click here and you would just move on. What is your US Social Security number? Again, you might have it, you might not. You would provide it there. Otherwise, you would say, I do not have or know my Social Security. And then same with the USCIS online account number. So usually, if your account was verified, then you can locate the account number here. But if you're unable to do that, that's a non-issue because you're already using this account in order to submit this application. So you can just skip it if you don't know it. And then what is your most recent Form I-94 arrival departure record number? You see, the whole point of this program is that you do not have it. So if CBP or USCIS issued you a Form I-94 arrival departure record, provide your Form I-94 number and date that your authorized period of stay expires or expired as shown on your Form I-94. The Form I-94 number also is known as the departure number on some versions of Form I-94. Note, if you were admitted to the United States when you last entered the country, you will not be eligible for parole in place as a non-citizen spouse or stepchild of a U.S. citizen. So technically, if let's say you entered the United States on a valid visa, then you do have the Form I-94 record, and in that case, you do not need to do the parole. So it's interesting that they're asking for it here, but either way, you most likely are not going to have it. So you would just move on. And that's also the whole point of this parole, because they will assign the I-94 number to you, and they will send it to you when they send you an approval. What is your current marital status? Obviously, in that case, it would be married. Then when did you marry your current spouse? You would provide that information there. What is your United States citizen spouse's or step-parent current legal name? So you would provide the name of your spouse here. And then what is your United States citizen spouse's or step-parent's date of birth? Easy. What is your U.S. spouse's social security number? That is also easy. When did you begin your continuous physical presence in the United States? So you remember that there is a certain date that we're going off of, which is in 2014. So you would just provide that date there, and that's usually the date when you entered the US without inspection. So have you ever been in any exclusion, deportation, removal, or rescission proceedings? So this includes if you were issued a Form I-862, notice to appear, but did not receive a hearing date in immigration court. Either way, if you have a removal order but did not depart the United States, or an unexecuted removal order, or failed to depart the U.S. pursuant to a government or voluntary departure, You will be presumed ineligible for parole in place under this process unless you can establish that there are significant favorable factors that outweigh the removal order and any other adverse factors. So long as you say yes, it is best to be working with an attorney on this process because things might be complicated. You need to locate your case and understand where you are as far as immigration goes. But if it's a no, then it's a no and you just move on. Now, that's another thing. Have you ever been arrested for charged with or convicted of a felony or misdemeanor, including incidents handled in juvenile court in the United States? Do not include minor traffic violations unless they were alcohol or drug related. So important, yes or no. Have you ever been arrested for, charged with, or convicted of a crime in any country other than the United States? Additional information about disqualifying criminal history, as well as information on criminal convictions that will result in a presumption of ineligibility that may be overcome if you can establish that there are mitigating factors, may be found here. So you will be able to look it up, but otherwise it's a yes or no question. Have you ever or are you now engaged in activities that could be reasonable grounds for concluding that you are a danger to public safety or to the security of the United States? Obviously, if it's a yes, then you're not going to get it. So of course, for a vast majority of people, it's going to be a no. And that's the whole deal. They're basically saying that we want to help reunite families and keep families together, but it's important that at the same time, we maintain these things and don't let any danger to be a part of our life in the US. Okay. Now, that's a good question too. Have you ever filed a Form I-601A application for provisional unlawful presence waiver with the USCIS? I said no, but if you do say yes, if you've ever filed this waiver before and it's currently pending, then you would want to provide the receipt number here. Again, based on what we've heard thus far, it seems like they want to prioritize these cases just because waivers, they pen for many years. So it's possible that you are in this situation as well. That's why you would want to provide it here, because hopefully, fingers crossed, they actually go to these cases first. All right. Now, explain how you qualify for parole in place, including information regarding the significant public benefit or urgent humanitarian reasons warranting a grant of parole, and why you believe you merit a favorable exercise of discretion. You need to read this. You must explain how you qualify for parole in place as a non-citizen spouse or stepchild of a U.S. citizen in the space provided, including any specific factors that support your request or may be considered in overcoming a rebuttable presumption of ineligibility. Include copies of any supporting documents or evidence you wish considered. USCIS will use the information provided in your parole request and supporting evidence, along with the results of background and security checks, and any other relevant information available to or requested by USCIS to determine whether parole is warranted based on a significant public benefit or urgent humanitarian reasons, and whether you merit a favorable exercise of discretion. So this part is very important. If, let's say, you have some negative factors in your case, I'm not going to go into examples because it's kind of straightforward. If you had some issues in the past with immigration, with criminal history, all of these things, the way to overcome it is here. So obviously, first of all, you would put minimum 750 characters, just describing why you believe you qualify for this program. And then you will be able to attach additional supporting evidence supporting your statement here. So this is very personal and something that you will need to do on your own, but just know that you're also able to submit additional paperwork, whether that's letters from community members, from church members, whatever, maybe you volunteer somewhere for years, whatever the situation is, just know that that's a possibility here as well. Now, getting into evidence, the fun part. So photo identity document. Here on this specific page, you will upload a copy of an official photo identity document showing your photo, name, and date of birth. For example, it can be a valid government-issued driver's license, passport identity page, just the bio page, any national identity document from your country of origin bearing your photo, any school-issued form of identification with photo, or any other official identity document with the photo. The copy must clearly show the photo and identity information. Expired documents are acceptable. So super important. From here, you would just want to scan it into one of these formats and just drop it here, and then just click next. Now, evidence of your relative status as a US citizen. Here, you would upload a copy of evidence that your spouse is a US citizen. So for example, it can be their US birth certificate, naturalization certificate, certificate of citizenship, consular report of birth abroad, or US passport. So just make sure that whatever it is, it doesn't have to be all of them. It can just be one document that shows that they are a US citizen, and you would scan it and drop it here. Evidence of qualifying relationship. So you would upload a copy of evidence of your qualifying spousal relationship to the US citizen. So for example, it can be a marriage certificate, so this is important, documentation of termination of any prior marriages if applicable. So if you or your spouse have ever been married before, you would need to drop the official divorce decree with a translation if necessary here. And on top of it, you will also include your current marriage certificate as well. Birth certificate with your non-citizen parent's name on it if you're filing as a stepchild, so that's not applicable to this video. And then death certificate of a US citizen spouse, if applicable. Okay, so again, if you've been married previously, please ensure that you're submitting a divorce decree, because otherwise it will trigger an RFE, and make sure that you're also submitting your current marriage certificate. All right, moving on. Okay, this is the hardest part, okay, because you need to come up with 10 years of physical presence evidence. It is complicated. The step number one and thing to know is that it does not need to cover every single month. So there will be in those 10 years, of course, gaps. Maybe you don't have anything. Maybe at that time you lived with 2 roommates and you just didn't have a lease agreement. Like 10 years is a long time. And I know that this is going to give people a real hard time. But again, this was what leads you to the green card. And without leaving the United States, they're making it exceptionally, I don't want to say easy, but easier. So we might as well just put all our effort into this. Okay, so upload copies of any of the following documents: any Immigration and Naturalization Service or DHS documents stating your date of entry. So for example, Form I-862, notice to appear. Rent receipts, utility bills, gas, electric, phone, or internet, or receipts or letters from companies showing the dates during which you received service. You may submit this documentation even if it only has the name of your parents or legal guardians, as long as you also submit other evidence that connects you to your presence at that address. They're being very flexible here. They're really giving us some room, but it's still important that we put as much effort as possible into giving them as much information as possible, because that's going to save us from a request for evidence. Tax returns or tax transcripts. So if, let's say, you have an ITIN number, or you have been filing taxes, whatever you've been doing, you would want to provide it here. School records, transcripts, report cards from the schools that you have attended in the United States, showing the names of the schools and the periods of school attendance. Hospital or medical records concerning treatment or hospitalization, showing the names of the medical facilities of physicians and the dates of the treatment or hospitalization. Official records from a religious entity in the United States confirming your participation in a religious ceremony, rite, or passage, such as baptism, first communion, wedding, etc. Money order receipts for money sent in and out of country, birth certificates of children born in the United States, dated records of bank transactions. That's huge. Obviously, it's kind of hard to live in the United States without a bank account. So you can just go ahead and submit, truthfully, 10 years of bank statements, so long as, it shows all the transactions and everything going on in the United States. Correspondence between you and another person or organization, automobile license receipts, titles, vehicle registration, deeds, mortgages, rental agreements, contracts to which you have been a party, insurance policies, receipts, postmarked letters, attestations by religious entities, unions, or other organizations to your physical presence, or any other document you believe is relevant. Look, you must submit sufficient documentation to establish your continuous physical presence for the entire period of time required, but you do not need to submit documentation for every day, week, or month within that period. USCIS will evaluate the totality of the evidence to determine whether you have established continuous physical presence for the required period of time. So since at least June 17 of 2014 for spouses, and that's that. Okay, so that's easy. I know it's going to be quite a bit of work as far as this goes, but otherwise you would just drop all of your files here and you would move on. Let us know under the video if you have any questions about this, because I know that that's going to be a challenging part of it. So whatever questions you have, definitely let us know. And then additional evidence you want to provide. You can provide any additional evidence demonstrating the significant public benefit or urgent humanitarian reasons warranting a grant of parole, and evidence of any additional favorable discretionary factors that you would like us to consider including any information that may be considered in overcoming a rebuttable presumption of ineligibility. Whew, mouthful. But you now see that even if something was off in your history, you can still overcome it through additional evidence and the statement we discussed previously. Okay, moving on. Check your application before you submit it, and you will be able to do that. And then just so you know, the filing fee is $580. As soon as you review the application, you sign it, it will forward you to a separate page where you will be able to submit your payment. And it's really great because you will pretty much right away have a receipt notice. You will see everything, and you will see the case itself and the receipt number and the receipt notice inside your USCIS online account. So everything happens very quickly from here. And then you're just periodically checking your account to see if there anything else that they're maybe requesting from you, or to just basically see if you got your approval. Okay, so you would go ahead and you would review it, and you can print it out, or you can view draft snapshot and you can just save that document. It's always good to just have it for your records, but all of this information will also stay here. So you would double check everything here, and then you move on to the signature page. You would say, yes, I agree. You would sign it, and let's see what happens from there. Yep, you would just go ahead, pay, and submit your form, and you're good to go. But let's go back to the video where we will just talk about a few more things. See you there. You're now prepared and submitted the form, paid a filing fee, and finally got approval. What happens next? First, it's important to know that DHS is not planning a re-parole process. If you do not apply for adjustment of status after an approval, you will begin to accrue unlawful presence when your parole expires. Any parole-based employment authorization granted by USCIS, category C11, will also generally expire at the same time your parole period expires, which is 3 years from the approval date. Here's the thing. You need to get your form I-131F approved, and from there you can apply for a work permit. You have two options. You can either apply for a work permit under category C11 or C9. C11 is a parole work permit, while C9 is a work permit through marriage adjustment of status and can only be submitted together with your adjustment application that will ultimately result in a work permit and a green card. Ideally, as soon as you get your approval, you would file for marriage adjustment of status. That's when you would also request a work permit through category C9. That means you will get that permit valid for 5 years, and if you file it under category C11, it will only be valid for 3 years, just like your parole. Main takeaway here. When your parole under this process is granted, you should not delay in filing their subsequent I-130 petition and I-485 application. Ideally, you will have your entire adjustment application prepared ahead of time so you can ship it as soon as you get your parole in place approval. Now, let's talk about the risks, because there are plenty of things to be concerned about when you're sharing so much information with the USCIS, since as of right now, they might not even know that you're here in the US. You're giving them your addresses, your names, everything. So could they use it for immigration enforcement purposes? Very valid concern. They're saying that they will not use information you provide in this request for the purposes of initiating immigration enforcement action unless they determine in its discretion that you pose a threat to national security, public safety, or border security. As you can see, it's 100% their discretion. Another big question, what happens if you're approached by ICE while your request is pending? According to them, they focus its limited resources on non-citizens who pose a threat to our national security, public safety, or border security. At the same time, filing a request under this process does not prevent ICE from taking enforcement action against you when appropriate under applicable law and policy. Finally, and this is the biggest consideration, what happens if your application gets denied? Now that they have all the information about you, will they place you in the removal proceedings? Here's the text directly from their website. We generally will not issue a notice to appear, or NTA, or refer your case to ICE for possible enforcement action solely based on your denial. USCIS maintains discretion to issue an NTA or refer the case to ICE for possible enforcement action consistent with governing policies and practices, including initiating immigration enforcement proceedings based on a threat, again, to national safety, public safety, or border security. There is certainly a risk here. There will likely be some litigation around this process. Things might get uncertain at times, but it is still a path to getting a green card inside the US without a need for a very time-consuming waiver and consular processing. Just to summarize this, here's how this whole deal will look like for you. You will submit Form I-131F online. We don't know how long it will take for them to process it, but let's imagine it's 6 months. During this time, you are actively looking into the marriage adjustment of status to understand how the process works, which you can learn it all from our channel. From there, the USCIS approves your parole in place request, and you receive Form I-797 approval notice that indicates the grant and validity period of your parole in place. It will also include a copy of your Form I-94 arrival departure record and Form I-94 number, which is that missing piece, something that you absolutely need to apply for a marriage adjustment of status, and you can safely do so now and get your green card without leaving the United States. Do you still have questions? Drop them in the comments, and we will see you next time.